everyone. Hope you all are doing well. My name is Mrs. Shivangi Sinha, Assistant Professor, College, Bharati Vidyapeeth, deemed to be University, Pune, and Faculty Coordinator of Madhyasthta, the ADR Cell, and would like to welcome you all for today's session. Dear students and viewers, it is a great pleasure for me to introduce you all to our today's guest, Mr. Swarnendu Chatterjee, who is going to speak to us on the topic Hardship and Force Majeure in International Commercial Contracts, dealing with unforeseen events in a changing world. Sir is an alumni of KIT School of Law. He is a managing associate in L&L Partners Law, Officers, Litigation, and also an advocate on record designated by Supreme Court of India. Sir majorly looks after the dispute resolution practices, possesses considerable experience in the corporate and commercial disputes, litigation, and ADR. This year, Sir was also conferred with Lex Falcon Award at the Lex Talk World Conference in Dubai. We are beyond honored to have you with us for today's session, Sir. Now, we'll begin with the session now.
You see, we are dealing with a topic today which was relevant a year back, and it is relevant in today's times also. Like there in this times of pandemic, like this time of pandemic was not known to anybody. And while drafting contracts, it's a standard clause for incorporating force majeure. But what to include in force majeure, let's say in international contracts or in domestic contracts, we don't foresee such a situation of pandemic where you get locked up in your home for months and you are unable to perform several obligations given, including contractual obligations, right? So it is not reasonably foreseeable. So let's see, the topic which I want to deal with, or rather which we should deal with today, is dealing with the notions of hardship and force majeure in the international commercial contracts. It's about tackling the unforeseen events in a changing world. Like, we don't know when we are going to go back to the normal, or we are going to live with the new normal. So this lockdown and this COVID times have taught us many things, how to cope with a lot of things, and what to include and what not to include, and how to go about our lives, basically in the commercial sphere and space. So let us start with the topic. Is, you see, in these days, COVID-19 has reverberated around worldwide, putting enormous strain on public health providers and enterprises of all sorts. And while adopting a method to control and regulate COVID-19 is critical, individuals and organizations must also be aware of their contractual rights, right, and the obligations during this period. In order to better understand the impact of COVID-19 on international contracts, as well as the remedies and exceptions available to the company owners and parties under such contracts, it is essential to take a study of the various concepts involved under the realm of this contract, which is the aim of the present discussion. And like these terms are basically coming from either French terms or Spanish terms, or let's say English terms. But force majeure is something which I would talk about in the Q&A session. It's not even like it's within the paraphernalia of let's say act of God. But can you bring everything under the act of God? No, it's not so. So therefore, this is a topic which needs like, how do you interpret it in the Indian scenario? What are the exceptions to it in the domestic law and the international sphere? So these are a few things which I would like to talk about today in this current session.
Thank you so much, sir. Then we'll be starting with a Q&A session now. So the first question that we have is, how did COVID-19 affect the international contractual obligations?
You see, first of all, let us begin by what is force majeure, basically. You see, force majeure means what? In simple layman's language, like an occurrence which is characterized by their extreme nature and unpredictability. The phrase force majeure comes from civil law in France and implies superior force. The concept of force majeure, on the other hand, does not exist in common law or English law. The significant question which arises today is whether the COVID-19 pandemic has rendered contractual duties impossible to fulfill, or whether the incapacity of a participant to fulfill contractual commitments is attributable to past choices or acts taken into consideration of the situation at present. To determine this, two concepts are extremely necessary. One is force majeure, one is doctrine of frustration. So, as I told you, or as we discussed, force majeure means superior force, like war, acts of terrorism, lockouts, riots, energy supply shortages, as well as catastrophes, which is usually referred to as act of God, as per Black's Law Dictionary. Will have to that no one can be held responsible for examples of situations which fall under the umbrella of force majeure, that is natural disaster. Now, force majeure provisions can be negotiated to incorporate a checklist of particular events and circumstances which will activate the provision, and they can be designed generally to and leave it up to the stakeholders are established procedures that a force majeure event has occurred. While each contract's phrasing for force majeure clause is different, but however, the three characteristics which I find normally in all contracts are as follows: like text exempting one or both sides from completing the contract if a force majeure event happens, a list of force majeure events that are normally negotiated by participants, the impacted party requirements, that is notice and mitigation obligations, and the prescribed remedies. So let's get down to the current situations. COVID-19. A company owner or a contracting party must be aware that in order for COVID-19 pandemic to activate the application of force majeure, the affected party must demonstrate that the pandemic, of course, it was unexpected, and it rendered the fulfillment of a contractual obligation or the contractual obligation impracticable or impossible. The impacted party must demonstrate also that fulfillment of its duties has been hampered or postponed as a direct result of the pandemic in order to establish this causal relationship. It is indeed crucial to remember that when attempting to depend on or exercise a force majeure clause, the impacted party is required to minimize the impacts of the force majeure occurrence. Commercial reasonableness is the criteria for mitigation under a force majeure situation. Now, exactly like what is going to happen and what is not going to happen, like a force majeure, like how do you incorporate like what is happening, or like this COVID-19 situation is is affecting you. How do you get how do you get to that? It's not easy, right? It's actually not easy. So like for this situation to creep in, or for a force majeure clause to get into this COVID-19 situation, as explained by Justice Pratibha Singh in her judgment in of the Delhi High Court regarding the rental issue of Khan Market. She made it clear that if you see that the force majeure clause is not included in the force majeure clause, if pandemic or endemic is not specifically included, then this would not cover. That is why drafting of the clause becomes more important. And even in Energy Watchdog, or let's say Mogniram Bangalore and other judgments of the Supreme Court, or Energy Watchdog being the latest, impossibility to perform might be a situation should be a situation which renders the entire contract void, not of a particular situation, but entire contract. But you see, Indian government came up with a notification last year that this pandemic will have to be treated as a force majeure situation. So, but let's say a situation under international contract or a domestic contract where it's a landlord tenant. It's a contract, it's a commercial contract. And the tenant does want to get a protection under force majeure clause that I don't have a job, but I can't pay. But in that situation, the courts have come down and said that no, you are enjoying the property, right? But staying there, it's not impossibility to perform. You can ask for some waiver, for some relaxation of time frame, but you cannot get a complete waiver or you by an order of the court, you cannot be said that you don't pay. Then how will the landlord survive? Then it's a way of it's a means of business. It's or a commercial it's a commercial understanding. Then we remember two cases which happened, once in Bombay High Court and another in Delhi High Court. In Bombay High Court, the custom authorities did not enforce the force majeure clause. In fact, the commercial entity who was importing things from Hong Kong and other areas abroad did not want to press the force majeure clause. Rather, they went to the court asking, seeking relief under Order 39, Rule 1 and 2, injunction, temporary injunction from invocation of the clause. But the court said, no, you have not incorporated this situation to be so. So it's not impossibility to perform. And you see, there are exemptions, like the construction sector. It cannot come under the force majeure clause. Construction contracts, building contracts, it's cannot, because those works are going on. But you see, in containment zones where you cannot move in and move out, so you have to practically see how you have drafted the contract. So that is why drafting of contracts and drafting of the clauses have become all the more important. And COVID-19 has taught us it's not a blanket thing that it's COVID-19, so therefore I get a protection of force majeure. No, you have to see the sector-wise division. You have to see whether you have incorporated endemic, pandemic in such a situation, and what is the nature, like whether the pandemic has completely stopped working, and whether it is a scenario which would, if you do not perform the task today, it would render the entire contract void and impossible. Mere hardship or mere technicalities to perform the contract does not incorporate a clause of force majeure, or does not give protection of a force majeure clause. That merely because there is a pandemic, and also because of a pandemic word mentioned, it's pandemic going on, so therefore I won't. It's based on the situation, basically. It's a situation which needs to be respected. If it's a situation, and you need to give notice also. Suppose we get into a contract, we both of us get into a contract, then what is it? In Delhi, you cannot move in and move out. It's a national lockdown. But let's say in Pune, you can move in and move out. You can, but there are movement, interstate movement of goods. But last year, when there was no interstate movement, how could you perform then the tasks? It could not have been. And if it's a perishable good, or it's a good, or it's contractual obligations of a time bound consideration, that it has to be otherwise, if it's not performed within the time frame, it will become void. So therefore, a lot of characteristics have to be taken into situation. It's not a blanket cover which happens, which is coterminous with COVID-19. It has several caveats going with it. So therefore, mere hardship does not entail or does not entitle a person to take a coverage under COVID-19 under force majeure clause. Second, all sectors are not covered. Three, if it's a national lockdown, then probably it is a cause for impossibility to perform. But let's say you can push it off to a certain situation. You can say today I can't do it, but 3 months hence, but 4 months hence. Then then there are mitigating factors. There are notice periods which you serve, or notices which you communications which you do. So that portion has to be taken into consideration before you enforce the force majeure clause under this current situation.
For your insight. My next question to you is, what steps should you take if you think force majeure might apply to your international commercial contracts?
You see, now, basically, what do you do? What actions do you take? Right? It's your question. Like, what actions will you take if you feel that force majeure clause? Then as I said, like it's a contract between India and US, but India is under national lockdown. You cannot move in and move out. First, what is the first step? Check the governing law and check the contract. It's a checklist which you need to see. What's the governing municipal law which is saying, what are the notifications of the government which are in force? Is it allowing international contracts to be performed? Is it allowing goods to be taken in and taken out of the contract. Like you see, let's say a contract between Sony and let's say Sony India and like Sony, between Sony and a dealer, right? It's an international commercial contract. Sony comes from so Sony goods come from, let's say, Korea or Japan, wherever it comes from. Now, if like if it gets stuck on the shores, it's not like you cannot. If the market is not ready for distribution, like the shops are not open, you cannot perform the contract, because you see, the best form of example of a commercial contract, it's, let's say, let's say a contracting party in India wants to sell a TV, right? Wants is in dealership of television sets, but we all know that the shops were closed last year. Everything was shut down. Now what do? Suppose you are a distributor, and you want to, there are 50 or 5,000 television sets which are coming from Japan. Where do you keep them? You cannot keep them in your go down for n number of days, right? And then pay the letter of, like, whosoever understands, like, with the custom law, there is a LC which goes on, letter of credit. What is letter of credit? Letter of credit means, like, they are sending it on credit, right? They are sending in the letter, bill of lading. You present the letter of credit and you take away the good, but you ultimately have to pay the money. How will you pay the money? Either by bank guarantee. There is a bank guarantee which is involved over there. And if you cannot pay, they will invoke the bank guarantee or the performance guarantee. But where do you pay from? You pay from your sale proceeds, right? If you cannot sell, it's impossibility to perform. And those television sets, let's say they are smart TVs. Mostly all TVs are LED smart TVs. Today, with the technology, what is there? 6 months hence, the technology may not be there. It may be outdated, right? It may not be conducive. And if the goods are locked down in a go down, it may not serve the purpose. You cannot yield the profits, or you cannot supply them in a time bound manner. So it's a frustrating event, or it's an event where you can say that, look here, I want to press the force majeure event. This is the governing law in my country. You cannot press the what do you say, the bank guarantee right now against me if I cannot pay. This is what, and you say that this 5,000 TV sets, what you are going to send me now, I am putting the contract in abeyance right now, because I am not being able to perform. I will not be able to perform for the next 90 days or 100, because the entire country is under lockdown. Look at the notification or the municipal law. You see, international law is at one side, municipal law is on one side. If let's say it's a contract between a Japanese entity and an Indian entity, Japan may be working, but India is not working. How do you reach out to the market? Mostly these people have suffered over here. Not the construction people and the real estate people have suffered, but those are not they don't come so much under the realm of international contracts, because labor is in it. Labor is mostly Indian, mostly what it is Indian. But you see, these supply chain contracts, or say international contracts of supplies, they have literally taken a backseat of electronic goods, electronic items, perishable items, chocolates. Let's say Swiss chocolates, right? Whosoever is from Delhi and Bombay, and let's say there are shops where you get foreign chocolates, where you get Swiss chocolates, where you get even watches, smart watches and all. If you keep them in limbo for a long period of time, the goods are not to be kept in perishable or semi-perishable, cannot be kept in a go down for a number of days. So that is why when you preempt such a situation, or you see, nobody can preempt a COVID-19 type of situation. But when you see that the lockdown is increasing day by day, or it's being extended beyond a period, so that is where the drafting of the clause becomes important. You say that, okay, maybe endemic or a pandemic is not there, but you see, this is the situation. Our country is treating this situation as force majeure. So I give you a notice that put me in the waiting period for 90 days, or suspend the contract. You have this 3-month notice period. You can suspend the contract, dealer contract, or let's say I cannot perform the contract henceforth and henceforth, because situation, I don't know when the situation would be conducive. Markets are not opening, sales are not happening. What do I do? So this is one of the steps which you can take forward. Then you see some contracts will use a general term, supervening event, which is outside the control of the affected party. Some contracts will not use the word pandemic and endemic ever. In the COVID-19 context, it is very important to keep in mind, such as disease, endemic, epidemic, pandemic, which are often listed as force majeure event, are a natural starting point when it comes to seeking relief. Other less obvious but equally common are natural disaster, act of God, may also cover COVID-19 impacts. However, it is often that the steps which have been taken by the governments which naturally prevent or hinder the contractual performance rather than the virus itself. You see, if the government today says all ports closed, then what do? You will file a writ petition in the High Court. But what do? The international party will say that the ship has sailed. The ship has sailed from from the shores of Shanghai or Japan. It will reach Bombay, Mazegaon dock. What will you do? Put your hands up. You say you go and file a civil suit or stop for getting an injunction. Don't invoke the bank guarantee because it's impossible. It's not the virus, it's the government regulation which is stopping me. So this is a thin line of difference. And again, while coming back, finally, we need to check whether the contract word excludes foreseeable event from the definition of force majeure. If it does, and the force majeure event, for example, anything was reasonably foreseeable when the contract was entered into, the contractual parties may not be entitled to such relief. Now, the key pointers would be the established causation, carefully check the contract test. The force majeure event must not be only or substantial cause of the inability to perform under the contract. In COVID-19 scenarios, causation can be difficult to establish as governmental measures change and new emergency legislation can be implemented. So what we need to check is the municipal law, the governmental regulations, the wording of the contract, the timing restrictions, like whether it is a time-bound event or not, any supporting information, the method of service of notice, and any ongoing notification or obligations which are there. Like mostly it is, mostly you see what we generally what we face as lawyers is that for parties is that, like they say, we can't do it because you see these are the supervening events right now. It's suppose today you enter into a contract with an international entity when you know that the situation is like this. And today a party entering into a contract in 2016 for 5 years may not have foreseen this situation. But today, if you are entering into a contract, you are foreseeing this situation. But today, if you try to say after 2 months that this is what is happening, so therefore I am taking cover under or shield under this protective cover. No, sorry, this is not going to happen because when you entered into the contract, the country was already under lockdown, semi-lockdown or whatever. There were restrictions in place, and you reasonably could have foreseen that if a third wave comes or a second wave comes, maybe the trade will be impacted.
Okay, thank you, sir, for answering this question. And now the next question is, what should you do if you receive a force majeure notice?
If you receive a force majeure notice, first of all, you should, again, reiterating what I said in the past two questions, it's a simple answer. You should see your contract, whether this event was, like, say, cinema hall owners, a recent case which I'm doing, cinema hall. Forget about international contracts for time being. Let's say you have a space, commercial space in a mall, and you have leased it out to PVR. Now cinema halls aren't operating. Correct? Cinema halls weren't operating till October 15th. Again, it is now not operating. So if the cinema hall owner comes and says, "हम तो नहीं देते जी, हम तो पैसे नहीं देंगे," will not pay. Will not use the space. We'll use the space. Space तो जैसा है वैसा है, but हमारी तो व्यापार नहीं चल रही है, तो हम कैसे पैसे देंगे? We put our hand up. So what will the mall owner do? Mall owner has to pay CAM charges. The space owner, you being the space owner, you are expecting the rent. It's a commercial contract. It's service charges. What do? You see, you send him whenever you get a notice of a force majeure event that look here, you can think about it reasonably. So what is a reasonable way out? It's a 50% waiver or it's a 25% waiver. It cannot be 100% waiver. And by when you can give some relaxations, if at all it was not reasonably foreseeable. Again, suppose today, suppose you have entered into a contract with PVR or any one of the cinema joints like 5 years ago, you could not have preempted this situation. So you can reasonably give him some relief if you think that this is not covered, that is not covered, like a reasonable person. What a reasonable common man would do, you would first think like that. Now, if you are entering into a contract, let's say October 15th, everything was okay, you entered into a contract in December or January. Question would be, could the contracting parties could have reasonably foreseen this situation? It's yes. Then you cannot put a stop. Then you say that you have to perform. Whether you are utilizing the space, then you leave it today. This is exactly which is happening right now. Parties are taking, mostly it's like it's becoming a force majeure clause nowadays. It's becoming more or less like a 498A. Like they can do anything and everything, and giving more or less a false premonition that okay, we cannot do anything, but they're sitting back and relax. They're enjoying the property also, and they're not doing anything also. But in the international scenario, the things change a bit. You see international contracts. You see normally contract is a private, and it's in the realm of private law, not public law, right? So if it's in the realm of private law, then like it's not a treaty that you will enforce Article 62 of the Vienna Convention of law of treaties like Pacta Sunt Servanda. Of course, international treaties cannot be as perimeter to a contract like let's say there is a commercial contract between India and Bangladesh to supply wheat or to give rice or to do this, that, n number of things, biotechnological contracts. Let's say patenting. Now the issue is about patenting, like getting life-saving drugs. What do you do? Is it impossibility to perform? No, it's not. It's an international contract. Can you take shield of force majeure? No. Pharmaceutical industry is open. That services are open. You cannot take shield. Now, suppose you are taking a shield of, let's say it's a contract of what? Let's say digital cameras supply, or you get supply of digital cameras, or let's say food items, foreign food items. There are shops all around India where you get foreign food items or foreign clothes. Let's say branded clothes like a Gucci or let's say an Armani or like that. Are not open. What do you do? Where do you sell? You can as a shop owner, I have to pay the rent and everything. So everything coming into the situation, these are the like when you get a force majeure notice, basically you have to see the supervening events or reasonability. What do you do? What do you want to do? Do you want to give him the relief? Was it reasonably foreseeable? So first you study your contract basically, and then you see what is to be done.
Thank you so much, sir. So in that relation, the next question would be, are there any additional remedies for the counterparty?
Like say your question, if I'm clear about, it's like suppose both of us are getting into a contract and you serve me a force majeure notice, then what is my remedy to get
Yes, yes.
the amount?
There are some step-in rights or right to cover. So that,
You see, what happens is mainly if you are, it's between you and the other party, right? If it could not have been reasonably foreseen this situation, then it's between you. You talk it out. Okay, let's yeah, it's like, sir, like this is a situation. It could not have been reasonably foreseen. So let us fix the rent for the next few months, or let us fix it for, let's say, 50% of the price or 50% of the consideration, or there are some additional reliefs like timely payment would be, like time gaps would be enlarged. So there might be the situation like, and additional relief. Suppose it's the supervening event is being used as a shield. Then what do you do? Of course, you have a right to, like, of course, if now there are certain laws. which say that, well, like you can have obviously you can recover if there's a recovery suit or an injunctive relief which you can give. But you see, nowadays courts also are going slow on that. But again, the municipal laws plays a huge part. Suppose if the dues are more than one. Now last year the IBC relief was suspended. This year nothing of that sort. IBC was not a relief which you could have gone into last, but civil suits are there. But again, the government notification was there. You see, you cannot enforce it as a force. You will invoke normally as a force majeure event. But let's say let's say a situation, a step forward. Let's say you have given 50% relief, but the person is not even paying that 50%, has walked away. Then what is your relief? Then you can seek an injunction against it, or you can invoke the arbitration clause against it. Look here, this was the understanding between us, but still he is not doing. So I have invoked the arbitration clause. You serve him a notice if the contract has an arbitration clause, but like in the dispute resolution clause, if there is arbitration mentioned, you give him an arbitration notice under section 21 of the Arbitration and Conciliation Act, and thereafter you seek, and you can seek section 9 relief also, pre-arbitration injunction relief also there, because in arbitration is the more, or you can seek like say when you go for arbitration, you can when the other party comes forward, it's more or less a monetary compensation which will, for which the fight is on. So you can obviously seek a mediation. Like in India, pre-packaged litigation system doesn't occur, or pre-litigation mediation, pre-litigation arbitration, pre-arbitration injunction takes place, but all these are a far-fetched phenomena which are not regularly practiced in the Indian scenario, though I feel it should be practiced in the ADR regime, where the burden of the court should be reduced.
Yes, ma'am. Thank you. So what is the role of force majeure certificate?
A force majeure certificate will give you like a hardship. It's an hardship certificate. It's an impossibility to perform. It's connected to the first and the second question. You see, force majeure certificate means like a government has said that these XYZ sectors we are closing down, and therefore under the National Disaster Management Act, we under the governmental powers, we executive power, we term this situation as a force majeure event. So you write to your contracting party saying that this is what has happened. So please grant me relief, as this is a force majeure event which could not have been reasonably performed, which is stopping me from performing the contract. So therefore grant me some relief. So when he grants you that relief, it's a force majeure event. So you have a relief. Like it's a again interstate, it's not between the government and all. So in cases of government contracts also, you can ask the government to give you some relief under this contracts where interstate travel or intrastate travel is stopped. So that is a purpose of a force majeure certificate. A force majeure certificate will give you some amount of relief. Like if the other person goes in for a litigation and says that, see here, it's like stopping the approbation and reprobation. If I give you a force majeure certificate saying that, okay, you will Miss Chaudhary will not I'm giving Miss Chaudhary this relief, and then I go to the court and say, look here, like I want the entire thing. So you can use that certificate saying that, see, it's approbation and reprobation, blowing hot and cold. He has given me this relief. Now he's saying different things. So first question, there cannot be approbation and reprobation. So it stops the other person, like invocation of bank guarantee also stops. Invocation of certain contractual clauses also stops. Basically, the coercive measures stops for a time being when you get a force majeure certificate.
Thank you, sir, for answering this question. And the next question is, what do you mean by the term hardships in contractual equilibrium?
You see, the international principles of, let's say, UNIDROIT principles of international contract, which includes provisions of, it's a 2004, it's a regulations of 2004, which includes the provisions on hardship. It's Article 6.2.1. It says where the performance of a contract becomes more burdensome for one of the stakeholders, the party is nevertheless required to perform obligations subject to following restrictions of hardship. Now, the following provisions mentioned in Article 6.2.1 followed by 6.2.2, which states that hardship exists when the onset of incidents fundamentally modifies the equilibrium of the contract because the cost of a party's performance has increased or because the value of performance of a party receives has diminished. The and the events occur or become known to have disadvantaged a party after completion of the contract. The events could not have been reasonably taken into account by the disadvantaged party. The events are beyond the control of the disadvantaged party, and the consequences of hardships, as outlined under 6.2.3 of unit right principles, are in the event of hardship, the affected party has a right to request renegotiations. The request must be made as soon as possible and must state the grounds for request. A request for renegotiation does not give the disadvantaged party the right to refuse to perform. If the parties are unable to reach an agreement within a reasonable time, either the party may take the matter to the court, or if the court finds hardship, it may terminate the contract at a predetermined date or on a predetermined terms and accept the contract to restore its equilibrium. Furthermore, hardship refers to situations in which the agreed upon performance is still technically attainable. Nevertheless, some underlying facts have significantly changed, making proper fulfillment of obligations it's not economically viable. Hardship is found on the premise that the contract's underlying circumstances alter in a manner that parties did not anticipate at the time of contract's conclusion. And while the contractual obligations are still fulfillable in principle, it does not make an economic sense. For instance, suppose the seller of a specific object loses it in the ocean. In theory, he should try to recover it from ocean's depth, but which is theoretically possible may not be practically and economically feasible. In the event of adversity, contract performance is not impossible, but it's hampered. Hardship is described as any legal, technical, political, or financial incident that occurs after the contract's completion that was unforeseeable at the time of contract was formed, regardless of the best efforts. In principle, hardship does not render performance impossible, but it does permit contract renegotiation. A hardship for provision can compel the parties to have new terms on board if ongoing performance has become unreasonably onerous owing to an occurrence beyond the parties' reasonable control. Further, hardship is found in the core concept of civil law and international law, namely pacta sunt servanda, which includes and indicates agreement and means agreements must be fulfilled. Private contracts are law between parties, and non-performance of certain clauses represents a breach of the pact, according to theory. Now, nonetheless, there is one caveat to this generally accepted principle of pacta sunt servanda. The restriction is known as clausula rebus sic stantibus, which is a legal doctrine that allows the contract to become unenforceable due to a substantial shift in condition. It's effectively known as the escape clause under the international contractual regime, provides an exception to the principle of pacta sunt servanda in general law. Even so, it's evident from a review of the unit right principle that the contractual clauses can be subjected to escape clause of hardship only when the events occur or become known to a party after contract's conclusion. The events could not be reasonably taken into account at the time of contract conclusion and are beyond parties' control, or the risk of the events was not assumed by it. The philosophy can be applied to any contract, including domestic and international business agreements, since the concepts of pacta sunt servanda and clausula rebus sic stantibus are essential principle of international as domestic law. It is essential to study them in depth. So basically, it's a hardship. If you remember the energy watchdog judgment of Supreme Court, what did the Supreme Court say? What the facts of those is? Now, the coal giant said that the pricing of the coal has rendered practically the contract void, impossibility to perform. Supreme Court said when you are entering into such an agreement, you are reasonably to foresee that the international markets will change and the prices will go up and down. Just because the prices of coal has gone up to a certain level does not make it impossible for the contract to perform. So financial implications are to be interpreted by the court. Like you say that you are into a business of petroleum products. Now, the prices of petrol depends on the OPEC region as well as the OPEC market as well as the international market. Now, can you today say that because the petroleum prices have shot up, I will not perform? It's not open because it's to be reasonably foreseeable. It's not a hardship thing. But let's say a situation where it is well, you could not have reasonably foreseen that situation when the contract was undertaken. Theoretically, a contract should not be performed theoretically, but practically also. So theoretical performance is not the key. Hardship should render practical performance as an impossible event.
Thank you so much, sir. Moving on to the next question. So, what does the doctrine of clausula rebus sic stantibus state?
I just told you, it states mainly the doctrine states things standing thus. It's like a status quo clause that a participant may withdraw from or cancel from an agreement if there is a significant change of circumstances there. You can see the clausula rebus sic stantibus is a provision in international agreements and treaties that allows an agreement to be rendered unenforceable owing to radically altered circumstances. One of the first standards of customary international law is this doctrine. Article 62 of the Vienna Convention on the Law of Treaties codifies this form of idea. Individual treaties frequently include it as a clause. This has frequently been employed as a theory in international law. Additionally, clausula rebus stantibus is a notion that permits the withdrawal or termination of an agreement or treaty when the parameters of the contract or treaty alter it fundamentally. It serves to get around the principle of pacta sunt servanda, because under Article 26 of the Vienna Convention, it provides that treaties are to be performed in good faith. So, according to Article 62, it is to be enforced. This particular clause is to be or doctrine is to be incorporated in the following conditions. There are fundamental change in the circumstances that existed at the time of the treaty was signed, but could not be reasonably foreseen. The parties could not have predicted such a radical shift. The circumstances have been a necessary condition for the parties assent to enter the treaty and agree to be bound by it. The modification has impacted significantly and drastically. No boundary has been established by the treaty, and this theory cannot be utilized to avoid treaty obligations if the fundamental change occurs as a result of a breach of the party invoking the change. This breach could be a violation of the treaty. Parties withdrawing from such agreements or treaties, invoking this doctrine in international relations. This notion can be used by a state in the following situations. At the time of, suppose it's a treaty, then what do you do? At the time of treaty's conclusion, the state believes that the treaty's provisions are favorable, but later discovers they are not. There could not be an internal scenario in a country where the treaty is judged to be destructive or detrimental. In such cases, state may consider withdrawing, terminating, or suspending activities or declaring the pact null and void for the time being. State sovereignty and strategy may demand the international community does not always adhere to the conditions of the treaty. The option is available if a state believes that a treaty is harmful to security or the security of its objects. This situation came up in the celebrated judgment of the United Kingdom of Great Britain and Northern Ireland versus Iceland. It's reported in ICJ reports 1973, page 3. Of the discussion or the judgment. As a result, it was observed that the states frequently apply this theory for internal purposes, such as defense of their own objectives. Through a condition of substantial change in the circumstances, this concept fulfills the goal of protecting states' interest while avoiding misuse also. Lastly, a party desiring relief under this clause must demonstrate that exceptional and unpredicted occurrences have arisen which has made the performing of this obligation overly onerous to the point where they have substantially modified the balance of the exchange under the contract quid pro quo, all of which has resulted into unreasonable imbalance of the reciprocal responsibilities.
Thank you, sir.
Yeah.
You made it very clear. So the next question is the principle of pacta sunt servanda releases a party from their contractual obligations, constitute an exception and a deviation. Can you please elaborate on this?
This was the exception, ma'am. This doctrine, Article 62 is an exception to Article 26.
Yes.
So this is an
And-
exception. Yes.
And so, what is the deviation in this?
Deviation is that it must be unreasonable. It should not be reasonably foreseeable. It is like it becomes so onerous, like it after the because the supervening event has occurred, and that is impacting, which was not reasonably foreseeable. Then you enforce this clause under Article 62 of the Vienna Convention, and even the states can do it under international treaties where it affects us still, let's say, national security or the internal policies of the state, whereby the nation's security again will be put to threat or compromise, like the nuclear treaty, like the nuclear treaties, where the state can use this principle. It's an exception, the all principle. The exception cannot become the rule, and private parties can also resort to this, but subject to, of course, the guidelines which have been, or the provisions of, or the situations which are mentioned therein, and can also use the judgment which I mentioned, United Kingdom, the United Kingdom of Great Britain and Ireland versus Iceland. This is a 1973 ICJ decision where detailed discussion on how one should go about it was laid down by the ICJ.
Thank you so much, sir. And the next question is, what are the obligations of parties claiming relief under force majeure?
See, looking into the various concepts, and also the principle of Balfour versus Balfour, that mostly we should see that all agreements are performed in the best spirit. But let's say a situation is such that where it does not allow you to perform, where it does not allow you to perform that case. So what is the, like, there is no uniform set of obligations that apply to parties claiming relief under force majeure or force majeure clause. But you see, it differs from state to state, it differs from person to person. What are the set of obligations? And exactly, ma'am, if you can tell me what exactly are you, there is no uniform principle as such. It's a like omnibus thing which I can state, but do you have a specific question to this?
So it means that before applying a force measure, what the parties must
it must see the
obliged to work.
See, they should see what is the contract all about.
Yeah.
What is the subject matter of contract? Next, what is the municipal law? What are the conditions prevailing in the country? What does the regulation say? What are the supervening constraints which have occurred? Whether this could have been reasonably foreseen or not. There are no universal set of principles. These are the 5-6 key points which should be kept in mind before applying this scenario.
Thank you so much, sir. Now we'll be moving on to our last question for today's session. That is, what are the legal consequences of the hardships clause?
The legal consequences of a hardship clause is that people generally take refuge under this clause, and if they do, if suppose I am facing, like the simple answer to this would be that energy watchdog judgment which I just mentioned. If you read the energy watchdog judgment, or you see Mivniram Bangaru judgment, or you see the other judgments regarding this section 56 of the Contract Act, the old judgments 1962 and 1965 Supreme Court. You see, Supreme Court in Energy Watchdog has categorically stated, like say I spoke just now about the business of petroleum products or say coal or anything, where prices go up and down. Let's say it's such a contract. Then question would be, if you enforce the force majeure clause, then the other party will definitely come and say that you could have reasonably foreseen this. This is not a force majeure clause, that coal's prices would go up and down or something like that. Like say if it's now another example, if it's a contract of dairy products. Now dairy is a essential service. Medical is essential service. It's under Essential Commodities Act. Now, can you say that a contract of essential services cannot be performed because I'm not opening my shop, I'm not allowing people to come in, you are not allowing people to come, that's fine. But today, can you take refuge under that hardship clause or that clause of force majeure? No, you cannot. So it depends from case to case. Normally, what happens is courts are normally slow these days to take into account all. But if it's such a thing which is evident from the face of it, then it becomes like a reasonably fair case for courts to interfere and we seek specific performance of that, and even an arbitration can be resorted to.
Thank you so much, sir. Thank you for today's session and for answering all the questions so comprehensively and covering all the aspects. It was really informative. And yeah, so this would be the end of our Q&A. Thank you so much, sir.
Thank you.
Sir, I, on behalf of Bharati Vidyapeeth, deemed to be university, and Madhyasthta, the ADR Cell of New Law College, extend a hearty vote of thanks for gracing today's session and for being a part on our initiative. A big thank you, sir, for sharing with us your knowledge, experience, and expertise in the field of ADR and providing your valuable insights on the topic. I'm sure the viewers have taken a note on the same and will be greatly benefited from it. Further, I would like to take this opportunity to place on record a special thanks to our Dean and Principal in Charge, Dr. Ujjwala Bindale ma'am, for providing her constant support and guidance. And a sincere thanks to the management of Bharati Vidyapeeth, deemed to be University, New Law College, Pune, for their support throughout. With this, we come to the end of today's session. Thank you once again.